Welcome to the Deep Dive. Today we are strapping in for a bit of a crash course in commercial law. Specifically, we're looking at the pretty volatile world of contract modification under UCC Article 2. Yeah, this is where, the practical chaos of the market really collides head-on with the meticulous world of legal agreements. We're examining a classic problem, right? Imagine you're a merchant, a supplier of essential goods. You signed a long-term fixed-price contract. Then, almost overnight, some global crisis hits, or there's a massive market shift and huge inflation, sudden supply shortages, maybe skyrocketing raw material costs. Suddenly, that contract looks like a path straight to bankruptcy. So how do you go to your buyer and ask for a modification, maybe a price increase, without falling into the trap of illegal extortion? It's that tension between what's commercially necessary and what's legally fair. That's really what we're here to unpack today.
Yeah, and what's fascinating here is how the UCC approaches this. It's really designed for flexibility. It fundamentally breaks with the old common law rules, making it much easier, on paper at least, to modify contracts. But, and this is key, that commercial freedom needs a strong safety net. And the UCC provides that through one single, really powerful mandatory limit, the obligation of good faith. Basically, if you're going to change the deal, you absolutely must be doing it honestly and fairly.
Okay, so our mission today then is to figure out exactly what good faith means in this specific context. We're going to unpack the two distinct mandatory inquiries a court has to make. And we'll use the landmark case, Roth Sealed Products versus Sharon Steel Corporation, as our main guide. It really shows how even a legitimate economic need can, well, fail the test if you go about it the wrong way. All right, so before we dive deep into good faith, let's just quickly handle the basic legal difference here. For anyone familiar with traditional contract law, what's the core distinction between modifying a common law contract versus one for the sale of goods under the UCC? What was that big barrier that the UCC just sort of swept away?
Well, the biggest hurdle the UCC got rid of was the requirement of consideration. Under common law, if you already had a binding deal and wanted to change it, like demanding a higher price, you generally needed new consideration, some kind of fresh benefit flowing both ways to support that change. Otherwise, under the pre-existing duty rule, the modification just wasn't enforceable. UCC Section 2209 completely changed that game. It says very clearly that an agreement modifying a contract for the sale of goods needs no consideration to be binding. I mean, that's a huge simplification. It lets merchants adjust more quickly to market shifts. But because of that, the official comments really stress that this powerful ability is strictly limited, and the only limit, Article 2's general obligation of good faith.
Okay, so consideration's out. That makes good faith the sole gatekeeper, basically, against unfair leverage. So if I'm that supplier facing ruin, how does a court figure out if my demand for more money is legitimate negotiation or just opportunistic pressure? Does good faith mean I have to be willing to lose money just to stick to the old deal?
No, not at all. Good faith here is defined much more rigorously. The modification actually has to pass what are essentially two separate gates, or tests. Courts have to make two distinct mandatory inquiries, and if you fail either one, the modification is invalid. Simple as that. Okay, so the first inquiry is the objective standard. This is really the why behind the modification. The court asks, is this conduct consistent with reasonable commercial standards of fair dealing in the trade? You, the party seeking the change, you have to show that your decision was based on a legitimate commercial factor, something like a major market shift, unforeseen cost spikes, supply chain issues, something that would cause an ordinary merchant in your shoes to seek a modification fundamentally just to avoid a loss. If the economic reason is genuine and unforeseen, you generally pass this objective test.
Okay, that part makes intuitive sense. If global steel demand triples overnight and my costs double, I've got an objectively valid reason to try and renegotiate. But you mentioned two tests. What's the second one? You said more crucial test.
Right. The second inquiry is the subjective standard. It's often called honesty in fact. This gets at the how of the modification, and honestly, this is the real guardrail against opportunism. It asks whether the party seeking the change was actually motivated by that legitimate commercial reason you just established, or, crucially, were they just using the market shift as a convenient excuse, a pretext?
Wait a minute. How can a court possibly know what's truly in a merchant's head? How do they determine if the reason was just a pretext?
Well, they don't need to be mind readers. They look at the party's actions and, critically, the means they used. The subjective test specifically investigates whether the methods used to get the other party to agree amounted to extortion or overreaching.
Yeah.
So even if you have a completely solid, objective reason to seek a change, like avoiding bankruptcy, you absolutely cannot use coercive or dishonest tactics to get that agreement. If you threaten not to perform the original contract, for instance, without genuinely believing at that moment that you have a legal right to stop performing, that fails the subjective test.
Wow, so you're saying a supplier could be facing like total financial ruin,
Yeah.
pass the objective test easily, but still have the whole modification thrown out if they use baseless strong-arm tactics.
Exactly. Necessity doesn't excuse illegal or improper methods. The subjective test is there precisely to stop a party with temporary leverage. Maybe the buyer is desperate, low on inventory, from coercing better terms unfairly.
Okay, I really need to see this in action. It sounds like proving that subjective bad faith could be tough. Let's jump right into Roth Steel Products versus Sharon Steel Corporation. You said this case is the classic example of this two-part good faith trap. So maybe set the scene for us first. What was happening back then? Okay, so 1972, steel industry's in a slump, right? Operating around 70% capacity, Sharon Steel, the seller, gives Roth Steel, the buyer, some pretty significant price concessions to get the business. But then early 1973 hits, and boom, everything changes globally. Demand skyrockets, capacity hits 100%, costs for materials, energy, labor, they all shoot up massively. Sharon Steel is suddenly looking at major losses if they stick to that 1972 contract price. All right, let's analyze Roth Steel Products v. Sharon Steel Corporation. First off, what are the key facts that really set up this legal fight?
The key facts really center on the coercion element. So, in March 1973, facing this cost crisis, Sharon decides it has to get rid of all those 1972 price concessions. They propose new, higher prices to take effect after June 30th. But here's the crucial part. When they presented this modification, Sharon made it crystal clear. They said they would sell no more steel to Roth after June 30th unless Roth agreed to pay the higher price. Roth initially pushed back, resisted, but, well, they eventually agreed very reluctantly. Why? Because their own steel inventory was critically low. The court used the phrase alarmingly deficient, and they knew they couldn't get enough steel anywhere else in that market.
Okay, so the threat was explicit. And what was the core legal issue the court had to decide?
The main issue was pretty straightforward. Did Sharon Steel's attempt to modify that contract price comply with the UCC's requirement of good faith? Specifically, did the means they used to get Roth's agreement, that threat, meet the subjective standard of good faith?
And what rule did the court apply to figure that out?
The Sixth Circuit Court applied exactly the two-part test we've been discussing, the one required for good faith modification under UCC 2209. First, they looked at the objective commercial standard, did Sharon have a legitimate reason? And second, the subjective standard, were they honest in fact, free from extortion?
Okay, so let's get into the court's analysis.
Yeah.
How did Sharon manage to pass one test but completely fail the other? Walk us through that.
Right. So, starting with the objective analysis, the appeals court actually disagreed strongly with the lower court here. The trial court had found Sharon lacked an objective reason, but the appellate court said that was clearly erroneous. They found that Sharon did demonstrate significant unforeseen cost increases. Raw material costs jumped between 4% and 20%, which is substantial. And the court agreed future losses were reasonably foreseeable. An ordinary merchant in Sharon's position would have sought modification to avoid those losses. So, objectively, Sharon passed. They had a good why.
Okay, so they had a legitimate reason.
Yeah.
They passed the easy part, maybe. Where did the way they went about it fall apart in the subjective analysis?
They failed right here because of that threat. The trial court found, and the appeals court agreed, that Sharon flat out threatened not to sell unless Roth paid the increased price. That kind of coercive conduct, basically refusing to perform their remaining obligations under the original deal unless they got more money, created what the court called a prima facie case of subjective bad faith. I mean, it looked exactly like extortion. Now, Sharon tried really hard to justify this threat. They argued, hey, wait, we actually had a legal right to stop performing. They pointed to a price increase clause in the original contract. Their logic was something like, the market price went up, our clause allows us to raise prices. Roth didn't agree to the new price, therefore Roth breached first, so we were justified in threatening to withhold performance.
Okay. Did the court buy that justification? Did it let them off the hook for the threat?
No, absolutely not. And this is really the core of the subjective test in practice. The court shot down that justification for two main reasons. First, the specific clause Sharon was pointing to, it only applied to cold-rolled steel. But the main dispute, the modification they were demanding, involved hot-rolled steel. So legally, the clause was irrelevant to the coercion. Second, and this is critically important for the subjective standard, the evidence showed Sharon never even mentioned this supposed legal justification back when they were actually demanding the modification in 1973. They only brought up this contract clause argument after the lawsuit started. See, for a threat of non-performance not to be subjective bad faith, The party making the threat has to genuinely and honestly believe at the time they make the threat that they have a legal right to refuse performance. Sharon's threat wasn't based on an honest, simultaneous belief in a legal right. It was just leverage, baseless leverage.
And the final conclusion from the court.
The modification was thrown out. It was ineffective. Even though Sharon had a perfectly valid commercial reason to seek a change, they passed the objective test. They failed the subjective inquiry. Why? Because they used coercive conduct, threatening to stop performing without a genuine, simultaneous, good faith belief that they were legally entitled to do so. That's bad faith.
Wow, that distinction between the objective need and the subjective means. That's really crucial. Let's try to cement that subjective rule, maybe with a more visceral hypothetical to really lock it in. Okay, suppose you run a highly specialized custom machine shop. You supply a unique critical component to just one major customer. Can't get it anywhere else. Suddenly, unforeseen global tariffs cause a massive 60% price spike in your essential imported raw materials. Continuing the contract at the old price means certain bankruptcy for you. Importantly, your contract has no termination clause for this situation. You go to the buyer and say, look, if you don't agree to a 40% price increase, we will halt delivery of these essential proprietary components immediately, and we both know your entire operation will shut down. The buyer, facing ruin themselves, desperately agrees to the change. So my question is, does the objective reality, the undeniable fact that you will genuinely go bankrupt if they don't agree, make your threat permissible? Or is this still subjective bad faith, just like Sharon Steele?
Yeah, that's a great hypo because it really tests the limits. And the answer is, it's still subjective bad faith. The modification would be invalid. You absolutely pass the objective test. I mean, avoiding a 60% cost increase that leads directly to bankruptcy. That's clearly a legitimate commercial reason an ordinary merchant would act on. But you failed the subjective test instantly because of the means you used. You explicitly threatened non-performance, and critically, you admitted or stipulated you had no termination clause allowing this. Your threat was legally baseless, made purely to exert pressure.
But hold on. If the whole point of the UCC flexibility is to allow necessary adjustments to keep commerce actually flowing, wouldn't voiding this modification just force the solvent company, the buyer, to effectively bankrupt their vital, unique supplier? Isn't forcing the supplier into bankruptcy arguably a worse overall commercial outcome than just letting them raise the price to survive?
That's a really powerful practical argument, and courts sometimes struggle with this. But the law, as articulated in cases like Roth Steele, holds pretty firm here. The subjective test isn't primarily about the economic necessity of the adjustment. It's about the integrity of the negotiation process. Now, if you, the supplier, had approached it differently, maybe said, look, we have this massive unforeseen cost increase. We literally cannot perform without facing bankruptcy. We need to find a mutual solution. Perhaps we need to agree to dissolve the contract. That conversation might be seen as good faith negotiation, but using your unique market leverage, the fact the buyer is totally dependent on you, to force a modification under the threat of illegally withholding performance. That's the textbook definition of commercial extortion the rule aims to prevent. The rule punishes the dishonesty, in fact, using a known-to-be baseless threat to gain an advantage, regardless of your underlying financial desperation. The UCC wants honest renegotiation, not commercial strong-arming.
Okay, that really crystallizes the difference. UCC opens the door for modification by ditching consideration, but it absolutely demands honesty in how you walk through that door. So now we have the full picture. How should someone, maybe a student facing an exam, approach a contract modification problem under the UCC? Can you give us a clear step-by-step framework?
Absolutely. Here's the actionable diagnostic checklist you should run through every single time you spot a modification issue involving the sale of goods. Step 1. Scope check. First things first. Is this actually a contract for the sale of goods? Does UCC Article 2 apply? If yes, immediately note that consideration is not required for the modification under 2209. That clears the deck to focus on the real issue, good faith. Step 2. The objective test. The why. Next, ask, did the party who sought the modification have a legitimate, objective commercial reason? Was there a real market shift, a significant cost increase, some unforeseen problem that would cause an ordinary merchant in their position to seek a modification just to avoid a loss? If this reason seems made up or just flimsy, you can probably stop right there. It's likely bad faith, and the modification fails. Step 3, the subjective test, the how. Okay, if they had a good why, now you look at the how. Was the party actually honest, in fact? Were they free from extortion or overreaching? And here you need to check specifically 3 things. A, was the objective reason they gave the real motivation or just a pretext? B, did they use coercive means, like threatening to stop performance of the existing contract? See, and this is crucial, if they did use coercion, did the threatening party genuinely honestly believe at that time that they had a legal right under the original contract terms to stop performing or terminate? Remember Roth's deal if the threat was legally baseless or if the justification was cooked up after the fact? That's strong evidence of subjective bad faith, a failure of honesty, in fact, and that invalidates the modification. Step 4, conclusion. Finally, bring it together. The modification is enforceable only if it successfully passes both the objective prong and the subjective prong of the good faith test. Fail either one, and the deal reverts to the original terms.
That framework really highlights how nuanced the UCC is here. It gives merchants freedom by getting rid of the consideration rule. But the price of that freedom is this strict requirement of, well, basic honesty, in fact. Yeah. Specifically to stop parties from abusing market power when circumstances change.
Exactly. The subjective test powerfully reinforces that having market leverage or even facing genuine economic hardship doesn't give you a free pass to override the legal standards of fair dealing. It really forces merchants to be upfront about their intentions and prevents the law from effectively rewarding coercive tactics.
All right, so to leave everyone with a final thought to chew on, think back to Sharon Steel. What if, back in 1972, they had been more strategic? What if they had drafted their original contract to explicitly give them the right to unilaterally raise prices, or maybe even terminate the agreement if certain unforeseen cost increases hit a specific threshold, say 15%? How would that pre-drafted contractual right have changed the subjective good faith analysis of their threat in 1973? It really makes you think about how careful contract drafting up front connects directly to whether a later threat is seen as legitimate good faith enforcement or just bad faith extortion.